Yes, sir. We have David Haeg.
David.
Hello again. My name is David Haeg, and thanks for this opportunity. There's been a Kenai grand jury investigating for 8 months, investigating evidence of corruption in our judges. It's still ongoing. Over 20 people have been subpoenaed, including judges and Judge Investigator Marla Greenstein, because there's evidence she's falsifying official investigations and certified documents to cover up for corrupt judges. After Ms. Greenstein got her subpoena, she hired an attorney to negotiate with the independent prosecutor the Kenai grand jury hired to help them. Immediately after this, the Alaska Supreme Court issued a rule change to suspend grand jury power to investigate, recommend, or indict. Article 1, Section 8 of Alaska's Constitution states, quote, "The power of grand juries to investigate and make recommendations concerning the public welfare or safety shall never be suspended." It is clear the Alaska Supreme Court did exactly this, apparently to keep our brave Kenai grand jury from finding the truth and informing we the people with recommendations and indictments. A November 22, 2022 memorandum indicates the Supreme Court even bypassed their own 13-member Rules Committee, so their unconstitutional suspension could not be stopped. We all know that you cannot fix this problem, but without your help, we the people may not be able to fix it either. So we humbly ask you pass a resolution protesting what the Supreme Court has done. This is a quote from Samuel Adams that sums up the danger we now face. "The liberties of our country, the freedom of our civil constitution, are worth defending at all hazards, and it is our duty to defend them against all attacks. We have received them as a fair inheritance from our worthy ancestors. They purchased them for us with toil and danger and expensive treasure and blood, and transmitted them to us with care and diligence. It will bring an everlasting mark of infamy on the present generation, enlightened as it is, if we should suffer them to be wrested from us by violence without a struggle, or be cheated out of them by the artifices of false and designing men. Let us remember that if we suffer tamely a lawless attack upon our liberty, we encourage it and involve others in our doom. It is a very serious consideration which should deeply impress our minds that millions yet unborn may be the miserable sharers of the event." And I believe that's where we're at right now. So we ask for your help again. I know you've helped in the past, and happy to answer any questions.
Thank you, David.
The delegates who wrote Alaska's Constitution, and I think I might have told you this before, but they said the power of grand juries to inquire into the willful misconduct in office of public officers and to find indictments in connection therewith shall never be suspended. Not one out of the 55 delegates disputed that. But our Supreme Court just issued an order stating a grand jury fulfilling an investigative function on a particular matter under this rule may not also issue an indictment related to the same facts and circumstances that were the subject of that grand jury's investigation. In other words, our Supreme Court went against what every one of the 55 delegates who wrote our Constitution said. I'm going to read you a case out of New York City to explain what this means. There's a book written by a lawyer out of Juneau, David Ignell. One of the most widely documented illustrations of the positive results that can be achieved by an American grand jury applying its common law investigatory and reporting powers comes from New York City. Up to this point, the ballot box, a newspaper crusade, public meetings, and a citizens investigating committee had all been largely ineffective. However, things began to change after a grand jury began to investigate. The grand jury's broad authority to subpoena witnesses and records made effective by its contempt powers and ability to indict witnesses for perjury, enabled it to obtain critical evidence. What we have right now is this grand jury in Kenai has subpoenaed in numerous judges and our only judge investigator for 33 years, but now they can't force them to testify. They can't go after them if they commit perjury. They gave a green light to all these judges and the judge investigator. If that ain't disturbing, nothing is. I'd like to go over one more thing that the Supreme Court said in their decision. Decisions as to what to present to the grand jury, including whether to present a matter requested by a citizen to the grand jury for investigation, rest with the executive branch. This in itself does not mean that an individual citizen has a right to present any matter directly to the grand jury for consideration. Yet here's what the delegate said. The grand jury can be appealed to directly, which is an invaluable right to the citizen. So anyway, my time's almost out. We're getting signatures to the legislature to start impeachment proceedings against all 5 judges of the Supreme Court. This is the beginning of them. I'd like to turn this in to you, and thanks again.
Thank you, Mr. Haeg. I don't